Imagine this. You graduated from a state college like University of Delaware. Not the most competitive college, accepting 64% of applicants and requiring no college entrance exam. But you have a driving passion to work in the law. Study abroad in Australia about Australian law. Gain some summer experience with a large pharmaceutical company like Janssen, pharmaceutical companies of Johnson & Johnson pharmaceutical companies, and even win a gig with a state solicitor's office in Maryland. Upon graduation from college, you still don't quite possess that competitive edge. And you began work as a paralegal and investment management analyst at a large international law firm like Morgan Lewis Bockius, LLP in Philadelphia. Most of your work had been focused on financial markets, working on regulatory and transactional matters involving mutual funds and registered investment advisors. You enjoy working in the legal profession so much that you applied to a top quartile law school like GW in DC and have the opportunity to perform more regulatory work and establish some good connections externally with the Department of Justice Civil Division's Intellectual Property Litigation Center. Get a chance to work as a law clerk at your old law firm, Morgan Lewis and Bockius, and graduate with high honors. Maybe along the way, before graduation, you're on fire and you get a coveted summer associate's job at a large international law firm like Orwick Harrington Soothcliffe in San Francisco. Better, you perform well enough to obtain a job offer earning as much as $225,000 straight from law school. Not quite the $250,000 that you would get at a law firm like Williams & Connolly in DC, who's going to get too upset over $25,000. Life is good, and it seems like it couldn't get any better. And in just 3 years, you're a managing associate, working on matters involving trademark and patent infringement, as well as trade secret disputes in both state and federal court. In your commercial practice, you even perform work with technology companies on contract disputes and issues arising under Section 230 of the Communications Decency Act. And on the good side, you also have a robust pro bono practice and have earned high honors through the D.C. Court's Capital Pro Bono Honor Roll. You're a good person. You feel good about yourself. You're doing well, and then suddenly, a hot potato case lands on your desk. What do you do? Ask Amanda Schwartz, a managing associate at Orwick & Briscoe, a law firm as old as the Levi Strauss Jean Company, and that has managed financing for Bay Area projects from the Golden Gate Bridge to the BART, the mass transit subway system, the hottest legal job in the city by the bay. In a rags to riches story like Kevin Lomax in the film The Devil's Advocate, getting an offer to work at Milton Chadwick Waters under the lead partner John Milton. But on September 11th, 2023, confidently she shot off an email to an unrepresented litigant, probably much like the typical clients she assists while performing pro bono work. And confidently she wrote, "I am an attorney at Orwick, Harrington & Soothcliffe. My firm was retained last week by Meta Platforms, Inc. to represent them in the above referenced case." Imagine that, an associate at Orwick, where attorneys are expected to rack up between 1,800 and 1,950 billable hours, with a second-level bonus for surpassing 2,200 hours, is entrusted with handling a case for the largest social media platform in the world. It's a plaintiff with no attorney and probably a rambling, prolix complaint. Living the good life in the Golden Gate City, earning more money than she could ever have imagined, and now an easy case and an open door to shine for a top client, add to her portfolio, and establish good connections. And she writes back, because we were only retained on this case recently, we plan to file later today a motion for an extension of time to respond to your amended complaint. Very, very short suspense. Answer now or never. And she continues, our motion will seek a 21-day extension to respond to the complaint and an abeyance on your motion for summary judgment and or default judgment. Why an extension? This may be a little more complicated. And she continues, but courteously writing, in accordance with the court's LCBR 7M, I am reaching out to confirm whether you consent to our filing this motion for an extension. Please let me know whether you consent or not at your earliest convenience today. 21-day extension. We're filing today. We need your answer. But following the rules, she is providing notice about her request for more time and seeking a favor of consent from a person with no attorney under a quickly ticking clock on a matter which may affect that litigant's litigation against a social media giant. How would you handle that delicate situation? On an ethical level, pressure is on. You have a chance to make a good impression with an important client, which could help you climb the ladder to the equity partner track. Normally a 7-year journey from associate to partner, and she's already 3 years in and rising. What would you do? Would you leave your heart in San Francisco? At 2:14 p.m. Eastern Standard Time, Amanda hit send on an offer you can't refuse to an unrepresented litigant on the East Coast, a 3-hour time difference. So if she had departed the office promptly at 5 p.m., she would have almost 5 hours to complete drafting the dispositive motion and is probably hoping at this point to obtain the plaintiff's consent. A job well done, a mission accomplished, and a feather in her cap with an important client. Regardless of whether she receives a response, Amanda is ready to electronically file the motion with the court before she returns home on September 11th. 9/11. 9/11. But there's some background on this case, which had actually named Meta Platforms as a defendant over 2 years prior, in a matter captioned Webb v. Fauci, filed in the federal court in Richmond on July 7, 2021. A matter that then only involved a simple, not complex request for documents under the Freedom of Information Act, and that had been assigned a tracking number OMB FOIA number 21-220 on March 23, 2021. Meta Platforms would not be added as a defendant until after the plaintiff had been ordered to amend his complaint and filed with the federal court in Richmond on August 13, 2021. The plaintiff had added Meta after the White House announcement on July 15, 2021 on flagging problematic accounts, including RFK Jr. and the Misinformation Dozen, whose accounts would not be suspended until a month later. This plaintiff's Facebook account, however, would be permanently disabled in just 4 days, not for medical misinformation, but for expressly safety and security reasons that could not be explained. In a final decision, no appeal. This unrepresented litigant decided to sue Meta Platforms under the FACE Act for blocking his access to a designated safe place of worship during the COVID-19 pandemic. And that case, at first only seeking to enjoin the White House from withholding requested documents pertaining to COVID-19, had gone all the way to the Supreme Court before that year was over, while the White House had asserted a presumptive claim of executive privilege reserved for matters of national security, and elected a right to remain silent, not issuing any further reply at all. neither confirming nor denying. If that was your case and you were Amanda, what would be your next move? Well, when Amanda got involved in September 2023, the case had already been on its third revival, now filed in a federal court in D.C. rather than Richmond on March 24, 2023. But the plaintiff and WebB Meta Platforms had been ordered to amend his complaint again on July 28, 2023, after the White House had been served the complaint and had told the 21-day deadline to respond, and on the same day that the deadline had told for Meta Platforms, which had already been served the original complaint. The amended complaint was then filed on August 4th, 2021, and Meta Platforms, already a party served the original complaint in the action, would have received an immediate electronic copy with the 21-day clock tolling on August 25th, 2023, long before the email was sent asking an extension request on September 11th. Additionally, Meta Platforms' registered agent had been served a copy in redundancy on August 11th, 2021, which still would have a deadline tolling on September 1st, 2023, if that date were used. And yet, after both deadlines had tolled, Amanda, at 2:14 p.m., fired off an email to an unrepresented litigant to request essentially his permission to excuse the deadline being missed and forfeit an entitlement to a default judgment as had been recently awarded against the Chinese government for $24 billion in a suit filed by the Missouri Attorney General. If that was your case, would you have sent that email? If you were Amanda, what would you do? Well, by October 13, 2023, when a motion to dismiss had finally been filed, Amanda Schwartz was gone from the case and replaced by a rising star partner at Orrick who specializes in the debt company litigation for high-profile clients like Meta Platforms, a social media network that connects friends and family around the world. Clearly, Meta Platforms is taking this case very seriously, and 2 years after its last start, that case is still pending before the Federal District Court in D.C., but has yet to proceed beyond the preliminary demurrer stage, even though under the federal rules, a judge must convene a pretrial conference within 90 days after all parties have made an appearance in the case. But perhaps the rules are for some and not for others. And what happened here? Did you leave your heart in San Francisco? This message was approved by Major Mike Webb. Honest.